have the secretary call the roll. Then we're going to adopt the committee rules and proceed to public testimony. Also, I want to congratulate everybody on the Permanent Rules Committee for being re-elected from the temporary to the permanent. Believe this is the only convention that I can remember where every single member of temporary rules committee was re-elected to the permanent rules committee. So congratulations. Yep, in the last 12 conventions. Okay. Please call the roll.
Here.
Reed Dunning.
Here.
Daniel Hunt.
Here.
Parker.
Present.
Suze Lucas. Here. Robert Gary.
Here.
Fran Dunwoody.
Here.
Rohit Choi.
Here.
Steve Atwell.
Here.
Amy Super. Here. Dave Wilson. Brenda Platt. Melinda Morris. Here. Chris Sasha.
Under duress.
Josh Flynn.
Here.
Becky Green. Oh, here. Sorry, Matt Patrick.
It's okay. I'm here.
Becky
Oops.
Green. Here. Here. Katie Jackson.
Go Navy.
David Westbrook.
Present.
Chuck Burnett.
Here.
Brandon Moore.
Wackadoodle. Here.
Cook.
Here.
Andy Yeller.
Here.
Chris Bird finally arrived. Justin Nichols.
Here.
Carmen Calderon.
Here.
Ian Pickens. Grant Clokey.
Here.
Gene Martin.
Here.
John Beckmeyer.
Here.
Perfect attendance.
Awesome. Same people. Excellent.
Thank you. First order of business, I would welcome a motion to adopt the temporary committee's the temporary committee's committee rules as the permanent committee's rules.
Second.
By Mr. Parker, second by Dan Pickens. All in favor, please say aye. All opposed? The ayes have it. The motion passes. We are now going to move on to public testimony. We have some people signed up. It's going to be 2 minutes for public testimony for the permanent committee because our time's a little more crunched. We have to conclude no later than 7 p.m. in order to ensure that we can get the permanent rules package submitted to the printer in time to get it passed out to everybody tomorrow. The first speaker, Colleen Aguilar, Epstein. Yes. Oh, just raise your.
Hello, committee members. Thank you for hearing my testimony. I'm Colleen Aguilar Epstein from SD8. I have submitted to you a amendment that I would like someone from the floor to please propose on my behalf. The bottom half of it talks about the penalty one, stating where it says the SREC shall also email, because I'm understanding the first half was already passed. So the SREC shall also email notification of the censure and its exact verbiage to all contacts within the GOP database and any other applicable voter contacts at their disposal who reside in the candidate's voting jurisdiction. This email shall be mailed within 10 days of the candidate's filing to be on the ballot, then again 5 calendar days before the early voting of both the primary and runoff, and again the day before the primary election and the day before the primary runoff. It's my understanding that it doesn't cost the party anything because they have a constant contact subscription. So it's my understanding that this would cost the party almost nothing, if not nothing, to mail this out. I was an endorsed candidate by the RPT when I ran for Plano City Council in 2023, and the candidate committee sent out mailings on my behalf. Same list could be used on behalf of the SREC to send out messages about the endorsement of the censured candidates. The reason I think this is important to codify how often it should be sent out is because so many precinct chairs put their names on the line and were actually challenged in their primaries because they put their name out on the line to get a censure. And some of them were successful. They got penalty 1 imposed by the SREC, but nothing became of it. So I understand that you all have already passed verbiage that would state that the censure would be on the website, and I think that's wonderful. I think this is another cost-effective way to get that message out and really help challengers to these incumbents. Thank you so much for your time.
Thank you. Next, we have Jim Pickle.
Good afternoon, members. Congratulations on all of you being reelected. That means I don't have to start over on any of this. Yesterday, Rule 47, which is the arbitration rule, was proposed. It was voted down, and I think at least in part based on the fact that there were a lot of questions asked by the members here that went unanswered. So I'm going to try as best I can, and you can ask more questions at the end, I guess, if the chair will allow you, to try to answer some of those important questions that were asked that we answered. Can we go to court now? No, not necessarily. The next one was confused about how it's presented from the court. If you're in a lawsuit, you can ask the court to send you to arbitration if there's a binding agreement that both parties have signed. That doesn't stop the constitutional power of the courts. It's just a common law practice that courts affirm and support and enforce arbitration agreements. So that gets us out of court. If you end up in court, you can use this to get out of court and have professional decision makers in the Republican Party decide your case instead of having district judges that might be Democrats interfering in our parties. This is another way for us to distance ourselves from state government and become an autonomous, free, and self-ruling association. Says somebody said, we already have county rules already in place. Yes, we do. This does not have any effect on those. This only kicks in if those current county rules and resolution proceedings don't work. Because right now, if they don't work, you end up going to court.
Please silence your phone.
It's not mine.
Go ahead.
State test looks like conflict state law. No, it doesn't. In fact, we'll stand for a law, and courts are very highly favorable to enforcing arbitration agreements. It's very rare arbitration agreement that doesn't get enforced by the court. It goes all the way up to the U.S. Supreme Court. So that we worry about conflict of interest. We have 62 SREC members. 3 of them will serve on the panel for your dispute, your county dispute. And I'm sure we can probably figure out a way to make so there won't be any conflicts of interest with any of those people. And I'm free to answer any of the questions if anybody has them.
Thank you.
Thank you very much.
Jennifer Graysman.
Hello, my name is Jennifer Groisman. I'm from SD8, and I had submitted 2 rule changes to my representative on the committee. One is to amend Rule 29 to add the committee chair of each SD committee shall appoint the committee members. The reason I would like this to be amended is that the chairs of the SD committees right now have 0 say in who is on their committee. The chair of the committees have to work with those who sit on their committees, and they know their area the best. Right now, the way it reads, the SD convention chair picks the members and the chairs. And I was the chair of my SD resolutions committee. And typically in years past, we've always worked with our convention chairs to decide who was going to be on the committees. And my chair this year basically started sending me people for my committee he said, they're on the committee, they're on the committee. I'm like, wait a minute. This person doesn't like this person. They hate each other. They can't work together. And he was like, oh, well, it'll be an interesting meeting. I'm like, no, it won't. I only got 2 weeks to do this job. So that's why I'd like to change that rule. The other one I'd like to change is that the chairs of each committee shall determine the method of submission from the delegates of the precinct convention in their respective SDs in paper or electronic format. The way it's written now is very vague. It says the chairmen of the precinct conventions, but I'm sure you all know this because
Time.
do I have, I can answer any questions about that one.
Thank you.
Okay.
Appreciate it. Next is Mike Sanders.
Good afternoon, everyone. My name is Mike Sanders, Williamson County SD 24, and I'd like to tell you a quick story. This is in regards to Rule 8G, open meetings and right to testify. But up until a couple years ago, we had a county chair in Williamson County who had our subcommittees in our county executive committee. The subcommittees were meeting in secret, and none of us who were members of the executive committee either knew about where they were meeting, when they were meeting, and we were not able to go and attend those meetings or to testify in those meetings. And so I made a motion in our executive committee to stop that practice and to come into compliance with Rule 8G according to the Republican Party of Texas. Well, our county chair at the time, Steve Armbruster, ruled me out of order and said, "No, you can't do that. You can't make that motion." And I challenged the decision of the chair, and our body voted to put this in place, to put this rule in place, that we would come into compliance with Rule 8G. So subsequent to that, the subcommittees, what they would do, because I wanted to record the video of the subcommittee meetings. So what they would do is they'd go into a subcommittee meeting and they'd immediately declare they were executive session. That way you couldn't record any of the proceedings. And so the problem that I want to make folks aware of is that right now in our RPT rules, there is nothing that defines what an executive session is. Nothing defines that term in our RPT rules. It's a term that's used there. It exists in state law in regards to public meetings. And it exists in Robert's rules, but there's nothing in our rules that defines when you can go into a closed session, what qualifies the reasons for going into a closed session, and of course, if someone arbitrarily wants to go into closed session just to avoid being embarrassed or just to prevent somebody from recording what's happening, they're allowed to do that under this existing rule. And so I would like to ask you to consider fixing this problem so that executive session actually people only go into executive session when there's a valid cause to do so, and then not just to prevent the proceedings from being recorded or just to prevent some individual from being embarrassed by having the public present. So thank you very much.
Thank you. Eric Blake. Patty Gibbons is next.
Mr. Chair and committee members, Eric Blake, Ellis County SD 22. You've heard from me a lot. I'll tell you some more. We have Rule 8G and Rule 14, both about open meetings. So maybe you want to fix those and merge them together. Maybe you don't. But we just yesterday, or earlier this week, maybe it was Tuesday, it's long. We passed change to 14B to say an official video recording or live stream shall be made of all general sessions and any meetings of any committee. What about subcommittees? We have a lot of platform subcommittees. They should be testified too, or live streamed as well. And can we please improve the wording to have the document that you're editing be available on the website instead of us having to commandeer some bootleg tiny URL off of SD members? It would be nice if we could guarantee, we have the technology, but we could guarantee that the delegates can follow along on the document that you're editing and not rely on some bootleg camera zoomed in on a projector. That's the only thing we have to know what you're editing so we know what to testify on the next day. Please, transparency matters. The delegates want to know the work you're doing so they can comment on the work you're doing. Thank you.
Thank you. Patty Gibbons. Next up, Patricia Simpson.
Good afternoon. My name is Patty Gibbons. I've been a delegate to this convention since 1988. I recently ran for city council in District 1 in the city of San Antonio. It's a rural, poor district. I'm objecting to a recent rule change that was made, that was brought to light from my SD 26 representative sitting here today, which is 8F. 8S, I believe. A person finally convicted of a felony under the Texas Penal Code is ineligible to serve as a county or district executive committee member. That's a precinct chair. So Not only have I run for office and met many of these people who probably have a conviction, but there are also people who fix elderly people's lawns. There are people who go to the store and buy grocery stores for those who are in their neighborhood who are poor. There are people who serve their communities in all kinds of capacity. But you want to say still, even though they have served their time, even though they've served their time, that they can no longer serve in civics. They cannot serve their community in this capacity in our party. So you violate the very rule 3 of discriminatory because you put on that list who you are going to discriminatory. If you want to write it so that maybe 3 years after when they've already served. I'll never forget Jeannie Wright out of Burke County, who was going around with voter cards telling felons you can vote. You do have the right to vote. It's not given away from you after you have served your sentence and your time. But this party, the party I've served for this long, is going to say, yeah, but you can't be involved in the civics. It's a travesty. And why did you all get voted here again? Because out of your temporary to your permanent? Because nobody ran against you. In SD 26, 51 people showed up out of 150 delegates. People aren't coming to the table. So we can't go out and call anybody. We were going to categorize it. I would ask that you take this off and revisit it when you have more time. It's a retaliatory resolution that came to you. We know it to be so, and it's useless. I needed their vote, and they voted for me. I was a one Republican out of 8 Democrats, and I made it to the runoff. Thank you.
Thank you. Next up is Patricia Simpson. Shamel on deck.
Good afternoon, Patricia Simpson, Senate District 1. I'm addressing 34C and the issue of tying a legislative priority to merely one plank. I'm here to say that is disastrous. Several issues have more than one plank which addresses it, like election integrity, protecting children, etc. And so I encourage you, please leave the language as is. Hold the line. Thank you.
Thank you. Michelle Mellon and then Amy Teal.
Okay, I would just like to comment on Rule 34C also, and also Rule 44. Rule 34C, our platform, it was discussed at the last convention that the entire platform was too long and they wanted to cut it back. Well, if you pass Rule 34C and make it so that every individual thing has to have a separate thing, that's just going to get more cumbersome and longer. And as was just stated, many of these things are related and can be combined. So I hope that Rule 30C stays the same. As far as Rule 34, I just want to speak in favor of protecting the precinct chairs if they do submit censures for candidates who do not abide by our priorities. As many things have been tried in the past to try and rein them in to represent us and not other outside interests, sometimes not even within the state. If this is not included, precinct chairs will be afraid. We've seen lawfare over and over and over again in recent years, and that is what will happen. So I hope that you will put that in there to protect precinct chairs from lawsuits if they do censure candidates who do not abide by our Republican principles. Thank you.
Thank you. Amy with Clint Stutz up next.
Okay, guys, I've got to point out we had 5 minutes allocated this morning, and times were getting cut. By the time we got into 3 minutes and 20 seconds, video was cut and audio was being jacked up over the people talking. And it wasn't just me. So this is something that you guys discussed as a rules committee. Many of you are on the SREC and voted to adjust that time. I'd rather not pitch a fit too much further, but this is the kind of thing that makes the party look bad. I wasn't the one in charge of that production. The party was in charge of that production, the SREC. So I'm going to ask that the SREC take a look at the times. It was recorded, and consider giving a couple of people that extra 2 minutes to speak tomorrow, because it's probably cheaper in the long run if everybody doesn't think that the party is just basically theater for a few key people. I wasn't actually going to address anything else, but the felony thing is an interesting thing because it kind of sucks that our president can't be a precinct chair. And unfortunately, he's not the only one who has dealt with a bunch of stuff in the law where felonies are thrown around and they really don't need to be felonies. There are some very serious actions that are serious on felony level stuff, but this is probably not necessary. Thanks.
Thank you.
Mr. Chairman,
Well, we gave you 2 minutes
Yeah.
today, all of it.
Mr. Chairman,
I said, we gave you your whole 2 minutes today. Yes.
Mr.
Clint,
Chairman,
please go.
Carmen Captain, I have a quick question. Do we know why, over here, Carmen?
Yeah.
Do we know why the candidate speeches were before the supplemental rules were approved? Because that's where the change occurred for the time.
Yeah, chair's not advised as to the order of the production. I know the SREC increased the time to 5 minutes for those splitting between 2 races. Yeah. Clint, go ahead.
Clint Stutz, SD3. Temporary committee rejected a list of what would be considered violations under Rule 44. I can understand the concern about item number 6 in that list, but I think the rest should not be so controversial. I heard a complaint that it was a laundry list, but you should understand that our principles and priorities are being violated in a laundry list of ways. I also think I heard someone say that this list amounted to a top-down rule, but I fail to see how that's the case since this came from the bottom up, and if added to the rule tonight, would be voted on by grassroots delegates. I think this list is needed because it brings clarity for everyone involved on either side of a censure. And that leads me to another issue, which is educating our elected Republicans on how to avoid a censure. My own rep was so uneducated on it, he thought not supporting all the platform could get him censured. We need to make more of an effort to educate those we elect. I know it's a lot on their side that they got to put the effort in too. But we need to tell them that we're happy to have them on the team and that all they have to do to avoid a censure is make sure they're moving the ball toward the correct end zone. Thank you.
Thank you. I have Richie Grant. Is that? And Ellen Cobb after that.
Hi, Richie Grant from SD1.
Sorry, I apologize.
Sometimes my handwriting is the best. I have a couple things that I would like to share. The felony one, I didn't get the number on that. My husband and I have worked in law enforcement for over 20 years at federal correctional institution in Texarkana. And to disenfranchise people who have served their time and done well and been cleared so they can vote, but they cannot be part of our political process for 20 years is way overreach. And I beg you to include these people because it is a massive number that we are pushing out. Second thing is on Rule 34C. I would ask you to say that a plank, at least one, not that it can only be a certain number, but it at least one. That would help that language drastically. And then on 44, my representative would not take phone calls. My representative voted with the Democrats more than he voted with the Republicans. My representative was probably number 2 violator of Rule 44. But we didn't even have a county legislative meeting about it. We need rules that have teeth, and that's your job. Thank you.
Mr. Chairman,
Thank you.
Mr. Chairman,
Yes.
can I ask us to put 34C back up on the screen so people can see how we modified it yesterday? Because some of the information that people are bringing forward is somewhat obsolete.
Yes. Next person, I was going to let her put it up on the screen, but
So my name's Anita Ellen Cobb, and I'm with SD1. Also, as a professional and in ministry that works with people who have had felony convictions, specifically related to drug-related issues in rehabilitation, part of that rehabilitation is trying to engage them in the process of caring about what happens to their communities outside of themselves and outside of their addiction. And if they are unable to serve as part of the civics process, then that would rule out them being able to actually invest in their communities. So I asked the committee to look at specifically shortening, if you want to limit the time, make it a couple years, make it, very short period of time that would limit them, but showing that requirements of good standing or letters of recommendation or treatment programs, something that would validate that. And then the question on 34C was brought up that it was also that you had changed it yesterday, but that it was going to someone was bringing it back up. So we did want to make sure that the language remains exactly what's up on the board right now. Thank you.
thank you. Melanie Cheney. Melanie Cheney. Bill Eastland.
Thank you, Mr. Chairman, members. I had passed out what I talked about when y'all were in temporary committee, two different rules changes to Rule 8. But I want to speak first, and this is actually related to, because this is a Rule 8 thing. If I'm given to understand you all have put that extra qualification for precinct chair. The problem is I've been told for years by lawyers, I'm not a lawyer, that the qualifications that in their election code are the only qualifications that are legal, i.e., you have to be a registered voter in the county and live in the precinct. Okay. And for years, we have had discussions in our county executive committee about trying to add additional qualifications when we fill a vacancy, but we can't. We can only go with what state law says. So I want to caution you to think about the fact that when you deny somebody because they're a Democrat, okay, but they haven't affiliated with the Democrat Party in the current term, and when you're trying to fill a vacancy, there's going to be a lawsuit. And I think we're going to lose it. So I want you to think about that. But the point is that the very first one of these things that I had put in there, any rule filling precinct chair vacancies on a county executive committee shall allow nominations from the floor. No vacancy in the office of precinct chair should be filled until the bylaws and rules have been adopted. The effect of that is to prevent tyranny in a county executive committee when you have somebody that is tightly controlling who gets nominated. So they prevent people from being nominated just because maybe they're in the wrong faction, not because they're a Democrat or something like that. The argument that's always used, we have these Democrats waiting to file, and we're going to keep them out. The bottom line is if you want to find out how to do it right, go to tarrantcounty.org. We have in our rules an extensive process for ensuring that we have a debate on the floor whenever anybody wants to have a debate on the floor, even if there's only a single candidate for precinct chair. And we also have a strong vetting process, but we don't prevent people from being nominated. And I want to, that's so obviously the other thing I'd put in there was a little thing to solve the problem with there's a particular problem in Dallas County, but there could be another problem in any county. Let's say you elect a county chair and that person dies before taking office. At that point, in our regular procedures, we have no way to trigger even the organizational meeting, but you can later trigger the meeting to fill the vacancy. My point about this, though, is that if you then allow any precinct chair to petition the state party chair to call those meetings, then you solve the problem. You can go on ahead and get started right away. Get your have your meeting to fill the vacancy first, then have your organizational meeting, and then you organize as a party. Ultimately, get it right back up to the state party chair to call the meetings. The other thing I want to talk about is Rule 44. And by the way, I don't know, I see a timer on me, but let me know when I'm out.
You're out.
I'm out. Okay. Thank you very much, Mr. Chairman.
Actually,
Appreciate
got
it.
more because I we didn't check it. Yes.
Deborah Damon, Williamson County. I'm here to speak about a rule amendment to 8G to add a section in. It was trying to be proposed last night, and I understand you guys were all tired, so I'm asking for you to please vote to pass it today. The rule has to do with compensate for the RPT to hire people who are already in a political connection and not being employed by the RPT. So the the rule protects the integrity of the Republican Party by preventing the concentration of political power, financial influence, and decision-making authority in the same individuals. And the rule comes down, you'll see who they are. I just didn't read it all. But conservatives believes that power should be dispersed and not concentrated, just like our constitutional system. And the public trust is difficult to earn and easy to lose, as we all know. This rule doesn't accuse anyone of corruption. Instead, it recognizes that confidence in the party requires avoiding situations that create the appearance of favoritism, insider dealing, or self-interest. The county executive committee members and convention delegates are elected or selected to represent Republican voters. Their duty is to advocate for principles and constituents, not to protect employment opportunities. Conservatives routinely support ethics rules in government. We object when elected officials create opportunities that benefit themselves, their family members, or their political allies. The same principle applies here. The Republican Party should be a vehicle for advancing conservative principles, electing candidates, and serving voters. It should not become a jobs program. Thousands of Republicans volunteer countless hours without compensation. So, allowing elected party officials, lobbyists, PAC operatives, and public officials to simultaneously hold paid positions can create the perception that influence is being rewarded. A registered lobbyist or PAC contractor already owes obligations to clients or organizations when specific policy goals, when those objections were let conflicts arise. You may think, well, we're going to lose talented people. No, you're not. You can still serve. It's basically asking them to choose between governing the party or being part of the paid party. Thank you.
2 minutes is not a very long time. Okay, we are Michelle Chaney. Is she here in the room? Okay. Seeing none that it reached the end of our list, is anyone else here to testify that hasn't gotten an opportunity to sign up? Please raise your hand. Okay. Seeing none, we will move on to the business of the committee. Hold on one second. Okay, won't apply. Anyway. So. Okay, we'll stand at ease for 5 minutes, go to the bathroom, come back, and then we'll begin business.
No, this is such a signal. It's a lot. Sure. So that makes a great game. I hear. You got a good report from Rick Barn. Yeah. It's time. Let's have a good coach. Yeah. So, yeah. Thank you. So, what sounds good? I that. Can you do that? Yeah. No. Oh, this is great. Our copy get you any. Our copy. Well, we tried out a 5 minutes. My hands are hang on. Yeah, yeah, I'm not listening back to anything. You know, well, there's ethics. I mean, it's still a lot. But you can bring out and realize it because yes. That's it's a lot. And on the one over last year. Looking at it. Oh, yeah. Now, so what? I think that's still be but that is that. Okay. He was going to try to push the veterans to very much want to start. Well, I'm here to tell you. There's a rules. Yeah, give me just a second. I found a voice. Okay. Reason why we do it, just give us two stuff. I need to street your house. Place different or carrot hash. But I don't think just so it should be around the NSRC. Yeah. She would use it 2 days, but yes, get it. It has a stakes tag on Saturday at adjournment. Like it today. Enough. Thursday. Yes. Yeah. Because this one, yeah. So yeah, I still say she can serve this or it's not. Yeah. Because as soon as the little just go down, these ones are like crazy. Great. You know what? You're all very. I always don't want to. Everyone's gonna get sued with the ballot act. One's gonna vote. You know. Yeah, anybody can do anything. Exactly. So let's. You're in a service. No, this is people with no money.
What is it? So great. Well, just Cliff. These reps don't even know what rules are. They don't them. They don't know. They don't know what it is. And we've got well, they do. But we need to do a clear job of educating principals. We have legislators.
I'm not. My son might be. I'm not sure. Monica went out of town.
Serve on like priorities. I get it. Get it. But I've been this is the last thing I would.
Okay, but it's inside the air conditioning or it's inside the house?
Like all college schools, so
You don't need anything significant now.
Where's
2007. But
Actual,
what I'm
convention
thinking.
notebook at the house, and I grabbed my old Elkhart Galaxy parts and manuals. Because it looks the same.
Let's do it. Much rather submit.
Wheels.
It's not done.
I think I looked it up on.
Work. So we're going to people are
They got another one.
please builder looking
Let's go ahead and do it. So 285 and it's what you said yesterday.
we call
I can sell you or should I just bring some by the office?
diet issue.
I will get some month.
But if we don't even try to contact him before we start throwing bombs,
I'm not going to be home really till.
we're not that close here. We will not even talk to you. So we got to have a
About the other day. Well, if you're recommending it, that's good enough for me. I'll get you the money for both. Right? Fantastic. Fantastic. Thank you so much.
why it's state and have it subsequently.
Order lunch, straight to work. It's like,
Have it. I think it's going to be that. So what I'm
Thank you so much.
Right.
Thank you.
Sandra G. She's a former assistant of the USA Defense Department. And here's Frank Gaffney. Grant Dunwood. Yes.
should have to
So he highly enjoyed your meal when it came.
Oh, good.
We ordered you another one. So,
There you go. All right, please start making your way to your seats.
take care.
Start in a little bit.
But this is good.
Somebody put it on the table?
Well, what on the table? Yeah. You know the motion to make?
This whole thing may be open because we're the permanent committee.
Rule the report from the temporary committee. Move temporary.
So it's a fresh document. We're a fresh committee.
It took me like a minute.
Like, why getting over me like that, dude?
Mr. Chairman, point of information.
Please state your point of information.
Randy Dunning, SD SD2. Just
Well, let me call the meeting to order.
okay. Sorry.
Call the meeting's called to order. Randy, please state your point of information.
Okay, just refresh me. We are operating on the we're operating on the rules afresh. We don't have to reopen because the other committee is dissolved, and we have full purchase on this particular rule set. Correct?
That is correct. It is a different committee. The form rules are not on the table, but there will be in about 2 seconds. Recognize Josh Flynn.
Mr. Chair, SD 15, Josh Flynn. I move to take up the work product of the Temporary Rules Committee.
Second.
Second by Randy Dunning. If there's no objection, hearing none, the temporary work product of the Rules Committee, which is the general rules as amended by the Temporary Rules Committee, is now on the table. Under the committee rules, we'll take up the rules in the order as provided by the committee rules, starting with Rule 46. Are there any motions relating to Rule 46? Seeing none, move on to Rule 44. Are there any motions pertaining to Rule 44? Yes.
Rohit Joy, SD8. I wish to move adoption of the language that Ms. Aguilar Epstein had given to the secretary during public comment. I mean, she passed it out, but it's the secretary.
Language. Can you?
You might want to read it, or
Oh, is this?
yes, the handwritten. Yeah, we're on 44.
Oh no, that's huh? No, it's he's moving someone else's.
Yeah.
I
thought we added this already, at least some of this. First paragraph.
Is there something different on there?
Rachel, is that written in a way that you actually?
Yeah.
Yeah.
So I guess not the website.
Hold on. We
yeah.
attached to end of paragraph.
Yes.
We're gonna need some time for the secretary to type it up.
Okay.
Yeah.
We'll stand at ease for 2 minutes while the secretary types up the verbiage. Yeah. How does this?
It's not your name for the.
Well, that's another.
It's here.
We're not something of my.
Send me. She's wanting to add it at the end of 21.
Rohit, you know what's already seen.
How much they cost?
Just not behaving correctly.
So just remember this too.
Yeah.
We have that verbiage. He wasn't moving that part of it. He was moving everything from the email.
Yeah. So it isn't, it's not just like, only.
It is. Physical relationship.
It's like, I mean, we sent them out for like our, like, our team goes for like, right?
Good. See, come over here, look. Over here, look. I'll show up.
Okay.
Oh, this is. Uh-oh. Here, I can make it
I'm
bigger.
falling apart.
I can make it bigger.
Actually-
Read all this one.
Actually, my,
See, this is
my,
it right here.
my up close vision went away when I had cataract surgery.
Oh, no. Okay. So in addition to the other ways that they can, you know, come in pharmacies here in District of Good.
Okay, but I'll say this, if the cost is more than marginal.
It says that the SRC shall have the authority. The initiation is the house.
Right. The SRC shall have the authority under the following conditions.
Yeah, but it says that the CRC shall initiate. The
Yes.
initiation
Hold
can
on.
accept.
Just what? Listen, you got to read the entire thing because
Okay.
this is one sentence.
Okay.
In addition What to is- the initiation of resolution of censure, a Republican member of the House.
Oh, he's got to look
Somewhere
at
all
that.
conditions are met. First condition they have to meet. Member did not vote in the House floor, but the House vote nomination order. Vote themselves first. Have to vote nominate. And they also, this also has to happen. Majority of the members of the House Republican Caucus recommend in writing SREC censure specific.
Yeah, that's wrong.
So they have to initiate, I think, or they have to send a letter requesting to the SREC. Then the SREC can do it without a CC or a DC.
Okay, but this says initiate to me. That's
fine. I'll just.
that. And this.
Because the House isn't going to write something like what a CEC does. They're just going to write a letter saying these members did not vote with the House caucus on the first
Okay,
vote.
so
We request you to censure it.
initiating the
Least,
request.
Just a letter request for censure. The SRC would initiate the actual censure.
And this is resolution.
Resolution. This is a resolution of censure.
Then make sure
This
that
is
it's
a
very
document.
clear so that nobody's not assuming that that is a request.
Yeah, well, it's, yeah, this one.
Yeah,
It's
the
the
only-
only
They
ROC
intended
of
to
this whole thing. We got rid of all the
email to-
language from the previous. This is all, it's always, ROC is request, is a resolution of censure. That's what this means everywhere at the very beginning. So, okay. All we have.
They could be writing for just the piece and they want to send it to our RPT in the state of Texas.
Well, it's restricted to district.
Well, down here it is, but up here it's not. I mean, it needs to be. like that.
Typically called that. Email.
Yeah, I think we talked about bifurcating to receive. And I thought that's what he was talking about.
Yeah.
It's all see and see. So, I'm just like, what? It's,
There's some others.
okay.
We have to amend this thing.
Hold on. We have, that was you, right? I thought I recognized the voice. I still not getting it from where it was. Hold on one second. What do you have?
Point of information.
Point of information.
Yes, sir.
Please state your point of information.
According to the, is it correct, sir, that the permanent convention rules signify that Rule 46 revisions should go before Rule 44?
Yes, we already went through that.
Okay, so just to confirm, point of information. So
Yes.
just to confirm, there were no amendments to Rule 46?
Correct.
Okay, thank you.
I'm done.
Pete,
Oh, I withdraw my.
amendments withdrawn. Do we have any other proposed amendments to Rule 44? Meeting's called to order.
Mr. Chair, Daniel Hunt,
Yes.
SD3. I have emailed a new amendment to Rule 44 that would delete the language that's there now and replace it with the language that was attached that I sent to the Secretary.
And that's in full.
It would delete all of the language and replace it with the language that's on the attached document that I sent to the Secretary.
All of Rule 44. I just want to make sure it wasn't a subsection.
No.
Okay. It's long, so we're going to put it, cut and paste it and put it in the live document so people have it.
It is shorter than the one I presented on Monday.
Noted.
Mr. Chairman, point of information.
Please say your point of information.
Andy Eller, SD 24. Do we not have an amendment on the table already?
It was withdrawn.
I'm sorry, I did not hear that. Thank you.
Second. Not yet. She's putting it on the screen.
Did you get it up? Do you want to? I'm going to let. Well, first, is there a second? Second by Brenda. If you want to lay it out, I'm going to have the secretary scroll through as you're laying it out so that everybody can read.
Thank you, Mr. Chair. This basically rewrites.
Mr. Chairman,
What?
request for information.
Please state your request for information.
This is a very long item. Is there any options for extension if the explanation eats the entirety of the affirmative?
Yeah, if the committee wishes to hear more testimony, they can always extend the argument.
All right, thank you. Sorry, Dan, I just want to make sure.
No problem. Thank you. This rewrite includes all of the language that we had added in the first 3 days under temporary committee. It simply rewrites the current Rule 44 into a much more understandable process for the CEC to go through the process, to know what they have to include and send and forward to the SREC if they do adopt a censure. So basically everything at the CEC level under this censure is the same as it was before. The difference is when it gets to the SREC, the vote to adopt the censure would be a simple majority, and if the SREC adopts the censure by a simple majority, penalty 1 would be automatically applied. Then there would be a second vote to determine whether we want to adopt penalty 2, or the SREC wants to adopt penalty 2. If they adopt penalty 2, then we would move on to a third vote, see if they want to adopt penalty 3. If they don't adopt penalty 2, then you stop there. And if penalty 2 passes, then you go on to consider penalty 3. It maintains the 2/3 vote of the SREC to adopt penalty 3. Trying to think what else is in there. There is, let's see, under E, standing, it adds a section that would allow the House Republican caucus to request a censure if any of the House Republican caucus members then did not follow the House Republican caucus rule and vote for the House Republican caucus candidate for Speaker on the first vote. And they would have to send a written request. It would have to be a majority of the caucus sending a written request to the SREC, and then the SREC would exercise that censure, the same censure process. And then it basically, if that happens, it doesn't go to the CEC or the executive committee, district executive committee. It would go straight to the SREC. It would still follow all of the same notification requirements and all of that. Where's that? Hold on. It maintains it's only for the past 2 years. They have to have 3 violations during that time. It spells out, like I said, specifically what a CEC or DEC would have to include in their submission to the SREC if they did pass a resolution of censure and was to forward it to the SREC. So the goal of this is many executive committees were just completely confused reading the way Rule 44 is currently written. They couldn't figure it out because literally the first sentence of Rule 44 is about 12 lines and it's one sentence with about 15 commas. So it's very confusing. The reason that I'm asking that the vote at the SREC to adopt the CEC or DEC censure to a simple majority is that the local executive committee is going to know their candidate or their elected official much better than most, a great majority of the SRECs. If say somebody in Orange County is censured, somebody in El Paso isn't going to have any clue to that particular person. So that's the point. We need to give the power to the local executive committee. If they say it, then the SREC needs to look at it, make sure it was done correctly, all the process was followed, make sure the violations are accurate and valid, and then proceed from there. So,
There's
Mr. Chair, I ask.
time.
Yeah.
Would
Thank you.
Mr. Chairman, for this to 25, I have a couple of points of inquiry.
please state your point of inquiry.
Thank
First
you, Mr.
point.
Chairman. Is there a way that the author could, because I'm looking at a lot of words here, is there a way that the author could, in a few words, just sort of bullet point the problems that this is attempting to solve?
Can we, can I invite a motion to extend debate to 10 minutes per side just for this
So
particular?
moved.
Second.
Okay. If you can withdraw the motion, we have another motion that I think will accomplish this better.
Mr. Chairman.
Just for now. Hold on. Chris.
Mr. Chairman, I move that the committee be allowed to consider informally for the next 5 minutes his motion. And if I can quickly explain what that motion means?
Yes.
That motion would allow us to bypass the formal I'm in favor, you're against, and would allow people or members to ask Dan direct questions about what he's attempting to do and facilitate time and easier inquiry and not really facilitated the debate for that.
It's been motion seconded. Are there any objections? Hearing none, we're going to consider this informally for 5 minutes. Mr. Byrd, go ahead.
Mr. Chair, if I could, just one thing I
Yeah.
want to point out, the part that's highlighted up there, I don't know why my Word wants to highlight that. It just, I couldn't get rid of it. So it's not supposed to be highlighted.
So there is no significance to that highlight.
Thank you.
Chris, go ahead.
How long?
Mr. Chairman, under the current situation, I'll just suspend my inquiry.
Of information.
Please state point of information.
The plot S12. Dan, does this mean we're gonna have a lot more censures?
You don't have to do a point of information. Just direct your questions to Daniel.
Is this gonna, I think there's a concern in this body that there's gonna be a lot more censures and that we're censure happy. Is this doing this, is it gonna bring more censures, do you think?
I don't think it's going to bring more censures. I think it's actually going to standardize the censures that the SEC will be receiving, because this makes it easier for the counties to understand what they're supposed to do and how they're supposed to do it and what they're supposed to submit. I don't believe that it will lead to more censures. I think the House and other elected officials' actions might lead to more censures or less, depending on how they perform.
Thank you.
Mr. Chair.
Andy, I got Chris, then Andy.
Dan, I have a couple quick questions for you. One, obviously you're saying that you want your big reason for bringing this as a complete and total substitute is because of concerns of readability or understandability of the item, right? I guess what I'm asking is why can't we had several members yesterday come up and say that they are not comfortable adjusting these thresholds. One, have you spoken to those members of the committee and asked them if they would move on that? And then two, why is this not coming? If we're primary focus is if we're going to do a complete substitute, why are we not adopting a substitute that maintains the same substance as the previous version, but doesn't adjust anything and allows us to bait any of those changes individually?
I guess the reason it really was done was just for simplicity's sake, could do it all at once to save from having to go through each step process. If somebody wants to offer motions to amend this, I mean, that's available. I have spoken with a few of the rule committee members about the threshold issue, and think this rewrite solved what I heard from those few members who had previously been against it.
Right, and then also why drop the SREC threshold from majority to 2/3 while the CEC is at 2/3? If we're like, what process are you emulating? Impeachment usually has that reversed.
Wait, could you repeat that? I'm sorry.
You've dropped on your stuff. You have dropped from a 2/3 threshold at the SREC, correct? You've reduced the threshold at SREC.
SREC was previously a 3/5.
Okay, I apologize.
Yes.
Thanks for the correction.
Yes.
You had it at 3/5 at SREC. Why the incongruency of a majority at the SREC, 2/3 at the CEC, when typically when you're talking about the actual punishing group, let's say impeachment, you impeach at a majority, you convict at 2/3.
Right.
Dan. Oh, sorry. I thought you were already through. Never mind.
I got Andy and then John.
This we've been talking about being a ground up and not a top down organization. This really makes sure that the local entity very convinced that they want this to happen. And it goes to the SREC. Again, you know, somebody in East Texas is going to know what a rep in El Paso, whether he's communicate. Hold on, he's got other people coming. Whether, you know, I don't know whether a rep over in El Paso communicates with his precinct chairs or county chairs or people if he visits his district. I don't have any clue what a rep over in El Paso is doing, but I can tell you what a rep in Henderson County is doing. So, you know, the CEC has a lot more contact, a lot more knowledge, a lot more experience with that rep than an SREC does. There may be 2, possibly 4 SRECs that a House member district covers. Well, that leaves 60 SREC who have no clue about that person, or not a lot of information at least. So this leaves that real control at the local level, but it still has the backstop of having to go and being checked by the SREC and making sure it would, it meets muster and is warranted.
All right. Thank you for answering my questions, Chair.
Calling on Andy Eller, but the gentleman's time's expired. Is there a motion to extend debate by 3 minutes?
I move to extend.
No objection? Hearing none. Go ahead, Andy.
Mr. Chairman, I was not asking for to ask any questions, but I will now.
I was.
No. Was yours a point of information?
No, I thought you said Andy Eller.
Yeah. Did you?
He did. He thought you were me.
I'm sorry.
Who was?
That was David.
I did. This is Andy Eller, SD24.
David.
I'm sorry. Yeah, because I did not ask.
Okay, David, go ahead. Sorry. There's David and then John. I can't see anyone in the row, so if you could raise your hand over the person's head next to you, that would be helpful if you're just in this row. Thank you. Go ahead.
Just curious, why did you lift the restriction, the geographic restriction in your version of this rule to allow any CEC anywhere in the state to censure any office holder anywhere in the state?
Can you point me to what you're talking about?
So in the original current 44 in Part A under the process is a Republican office holder representing all or portion of the county or district can be censured. In your rule, that restriction is no longer there.
No, this still has that same restriction.
I looked, I couldn't find it. Where is it at?
If it doesn't, it was a typo.
I think if you look under E, I think that.
Under E standing, a CC or DEC will have a CC or DEC will have standing before the SREC on the following conditions. 1, within the district an office holder represents, in other words, a county office holder, state representative, state senator, U.S. representative, any single CEC in the district may submit a resolution of censure to the SREC. For statewide offices, governor, lieutenant governor, speaker of the House, Supreme Court judge, U.S. senator, then a minimum of 10 CCs would have to submit a resolution of censure. So this actually ups the number required for statewides, because prior it just said, like for Speaker of the House, any county could do it. Now it's going to take 10 counties to do it. So I don't know if that answers your question, but it's their understanding in E.
Mr. Chairman, Grant Dunwoody, SD7. I'm one of the people he spoke to about the threshold issue, and my concern was the threshold issue on penalty 3.
Let me go to John first, and then.
Oh, I'm sorry.
John, go ahead.
Daniel, in your layout to this, it was proposed as a rewrite of what we currently passed last night for easier understanding. However, there's a whole section in here allowing the SREC to go to the House caucus and initiate a censure.
Right.
That's a little more. The question is, do you believe that's a little more than a rewrite for understanding?
It absolutely is. Yes.
Okay.
And when I was laying it out, I said it's a rewrite with a few changes, and that's one of the changes, one of the additions.
Would you consider that a pretty substantive change?
It is that is not contained in the current Rule 44. Yes.
Yes.
Hear a motion to extend this period for 2 minutes.
So
From
moved.
Chris Sasha, second by Josh Flynn. Any objections? Hearing none. Go ahead. Grant.
Yes, I'm one of the ones that spoke to him earlier about the threshold issue, and I'm satisfied as far as that's concerned. I did run some of this language by some folks that I respect very much. And one concern was by formalizing the procedures that there would be the ability for a chair to squash a censure just by like a simple point of order, and procedurally, is that a concern for either the author or for the chair of this committee in terms of how the language is structured?
I think, in fact, I know it's happened already under the current system. There's county chairs who, precinct chair would make a motion to initiate a censure, and the county chair would say that's out of order. So, I mean, it already happens.
Thank you. Go ahead, Justin. You got.
So this is an honest question because I want to try to get there if we can. This rule, take out the specific language. What problem is it trying to fix? Is it because the process was so convoluted no one could follow it? Was it because people were committing bad conduct and getting away with it and 44 was insufficient? Was it that the sanctions were illegal and we needed more, or there was not enough indemnification and more precinct chairs were worried that they couldn't censure their representatives safely? Just thematically, what does this do? What does this fix that was so bad in the prior? Not so bad. I don't want to use any loaded language. I want to be fair and just tell me,
sure, what
are we doing?
Is all of the above a valid answer?
Okay.
There many county chairs and precinct chairs in several counties around Texas had problems even understanding the way current Rule 44 is. They didn't understand what the process was. What was the, how do you start a resolution of censure? They just had no idea. They didn't know what they were supposed to send to the SREC if they did censure. They didn't understand the notification process. They didn't understand they had to have a return receipt or some kind of proof that they had notified the candidate 7 days in advance. And so that was one of the issues. There were many counties that, well, we talked about earlier in the.
We've hit time, so if you can wrap up the
Okay.
answer, and then we'll.
In previous days, we had added the precinct chairs into the indemnification. There were many precinct chairs who were threatened with lawsuits. So they were scared to death. They didn't have the money to hire an attorney or whatever. They were, the whole idea of that scared them. Now, is this going to prevent that completely? I doubt it, but it will give them some peace of mind.
We've hit time.
Yeah, there were. I would keep going. I'm out of time.
Let me, just because you used up your 5 minutes, and I want to make sure that when we go to for and against, everybody has enough time. Motion add 2 minutes to the time limits so that there is some more time for as well as against. Okay, Randy, do I hear a second?
Just to be clear, that was 2 minutes additional.
2 minutes additional for each. For and against.
Okay, but he had no against 5 minutes.
Yes.
7 minutes.
Yes. So we're still going to be even. If there are any other issues raised, I want people after hearing this also to be able to at least say something, even though I'll have to quickly. Is there any objection to extend time 2 minutes or 2 minutes and for a total of 7?
No objection.
Of which 5 minutes 4 has been elapsed. Hearing none.
And Mr. Chairman, I just want to make it clear, I am willing to listen to amendments.
Do you want to speak for?
To consider. I'm just saying I'd be willing to consider amendments and even potentially friendly amendments.
Hold on.
That's all I'm saying.
Okay. Anyone else want to speak for or against?
Randy Dunning.
Randy.
For.
Against.
Randy is for. What's it? Yeah. I'm gonna do John first.
Mr. Chairman, Andy Eller, SD24.
Wait.
I have a point of information.
Yes, please state your point of information.
Were you aware that I was, as chairman of the resolutions committee on the SREC during the censure process, I was contacted multiple times by county chairs and precinct chairs on how to do censures?
I was not aware of that. John.
Okay, speaking against, we tabled and then failed to remove from the table a amendment that was much like this, however, not as egregious as this one is in its top-down, nature. We're now reaching out and allowing the SREC, which by the way is not part of a county park, to reach out to the House of Representatives, State House, and to initiate censure. I would at this time, if it's in order, like to move to refer this proposed amendment, if that's in order.
Thank you. Randy.
Okay, the one thing I first looked at this thing and I said, I don't know if I want to open this whole thing. But the more I read it, I realized it's substantively the same with a few additions, which could probably be debated. What I like the most is the process section where we've added the 3 bullet points that explain exactly how to do this. And I think that's the big value add. And I would want to put that even in the other one if this fails.
Thank you. Anyone else?
David Westbrook, SD19, against.
Go ahead, David.
The process section that the previous gentleman just mentioned is where I have the biggest problem with this right now, because it does in fact say against any Texas Republican officeholder. If we can amend that to include the geographic restrictions that were placed in there to protect and prevent rampant abuse of this by any CEC anywhere in the state against anyone else anywhere in the state, I would be open to considering it. But until then, such time, I would not.
Mr. Chairman.
Mr. Chair, may I ask where he's asking that be added? Is that, what is that?
In C under process.
In that first paragraph?
Yes, on the first part.
Where would you recommend that be placed?
If you want, you can get to and you can Jim comments to get up for your seat.
If you would just tell Rachel where to put it.
There's nothing on the floor right now. Chris, go ahead.
If there's none for, I'd like to speak against.
Yeah.
Oh, okay.
I've gone through this. I have my concerns of the threshold adjustments. I'm not really down with it. I still feel like the committee has walked away and built a strong Rule 44. Per the notes from the committee clerk and council, we have expanded the ability and process details, including applicability and process details. We changed the vote threshold from SRE penalties to 3/5 of full membership. Penalty 1 details, which I think were very important, are omitted in this current copy. We do actually go back to having to use the verbatim language as this is currently drafted. Which is, if you want to sit there and read out whereas, therefore, be resolved, I think this poor political messaging for us to party make when we're actively trying to communicate. I don't want to show people a resolution. I want to tell somebody that they're a scumbag. The next thing is that we have the indemnification language that we updated there, I think offered by Dan and was largely supported by the committee. We have new requirements. We deleted a requirement, that's fine. And we actually already have the published party censure stuff. And we did some minor changes. We have a strong Rule 44 that is being presented by this committee to the floor. This is a massive substitute. It has substantial changes. There are a couple things I like out of it, such as the going out of the CEC for multiple cancers statewide. It's a fair change. Several items that we could pin pull from here, but I think this full substitute is just not a wise way to do this. Thank you.
Mr. Chairman.
Thank you. Yes.
Amy Super SD12. I'd like to speak in favor.
Okay, go ahead.
So I'm going to speak to you as a precinct chair and an area leader in a large urban county that entertains such a resolution. The manner in which information was distributed all the way down the chain was so confusing, so frustrating. Every single level, for every single precinct chair that was involved, for every area leader that was involved, for our county chair, for our legal counsel, for our constituents, for the elected officials themselves. It this simplifies that in ways that I do not see in what we have currently decided to go with. And it pleases me to see it in this simplified form because most of the people who will be actively engaged in this need it to be that simple. They need to understand the process. In their minds, there was a process they thought they voted on at this last convention. And then when it was time to actually do it, a bunch of meetings were held by a bunch of people, and suddenly all the rules changed. And everything they had sent, everything they had worked to do was moot and gone. And this seems to simplify that in a way that I think that it would appeal to those of us who are in the trenches, who are trying to manage this on a county level and on a precinct level. Thank you.
Thank you. Dan?
Dan Pickens, SD 28. So a lot of the questions I have already been put forth, especially the change on D2, the 50%. But what I really don't understand, I like a very simple document, which I had no problem with the original form that was in there from 2 years ago that was modified. The report from Andy when we filed our censor was pretty straightforward. It was really, here's the form, fill it out, send it in. That was it. It was simple. But what was also important is the restrictions and the level that you had to reach for the SREC to truly do the censor, I think was great. I like type. I like limited number of censors. This here is full of a lot of stuff which I really don't totally comprehend. I can go through it. There's another section up here that talks about number 3, citations. You've got all these forms, bill numbers, committee, subcommittee records, official posting, transcripts, official video timestamps. Who's going to go through all of that? I don't like, I like a little bit of information, but this is overboard. And there are sections that I don't believe is legal. And I don't know why people had problems with the other one. All you had to do is talk to Rachel or over here to Andy. The form was sent and it was easy to fill out. Nothing to it. So I'm definitely against this.
Thank you. 15 seconds.
Point of information, Mr. Chairman.
Yeah.
It is number 3, citations to official legislative documents, all those things. That only serves to provide documentation that justifies the bullet point or the different violations, correct?
I got to say, it is what it says it is.
Okay.
Oh, 15. No, Susan. Say 4 against and then.
This is Susan Lucas, SD5, and I am commenting
4 against?
for acceptance of the specific item that we're looking at this moment, number 3.
We're not looking at that. We're looking at the whole amendment.
Um,
Are you speaking for?
for the time being, I'll say that I'm for the whole.
Okay.
In terms of making things simple, simpler for the for the whole, I also, as we were going through this and trying to answer questions from the SREC, that I agreed that it was adequate. But when I started trying to answer the questions in the CEC, then that was no longer true. They were very confused.
Time. Then we had, forgot who was next. Oh yeah, Josh was next. Okay.
Josh Flynn, SD15. I understand that we want to make this stronger, and basically listening to everybody, I think the best way to do this, if you want this to happen, is you're going to have to bring it in 2 years. But as opposed to just bringing this whole wholesale with all these different changes, bring it in the simplified form that you're talking about that's not changed, so that we can get that and we can understand, we can put it in our heads, and then we can change that substitute language. Then take each one of your changes and work on those and put those in. But right now we have all these different substantive changes and a simplification, but it's too much to because we would spend weeks trying to fix each one of these items.
Thank you. Any more against? Seeing that, no other further discussion, we'll move to a vote. All in favor of the amendment, please say aye.
Aye.
All opposed?
No.
The nays have it. The motion fails.
Mr. Chair, can we have a roll call vote?
You can make a motion for a roll call vote.
I move for a roll call vote.
Second.
The chair will do a standing vote, and then you can do a motion for the roll call.
Sorry, C2.
All in favor, please stand.
So roll call?
Well, now, actually, we don't need a standing vote. I'll just do the motion for the roll call vote. That's fine. All in favor of having a roll call vote, please say aye. All opposed?
Right. Because you're scared.
The nays have it. The motion fails. Any other motions? Yes.
Can we do the standing vote?
That's for division.
Just ask for division. Division on the original amendment, right? The amendment vote, correct?
The roll call vote.
You want to do a
Request for
division on
division.
the roll call?
No, on the roll. Yeah, that's the last roll.
No. Are you asking for division on the motion to have a roll call vote, or on the motion on the amendment?
Motion on the amendment.
I think that's
Okay.
out of order.
All in favor of the amendment, please stand.
We're doing-
All sit. You can sit. And then all opposed, please stand. The noes have it. The motion fails.
Mr. Chairman,
Mr.
Brandon
Chair.
Moore, SD21.
Yes.
Just wanted to notify or indicate abstain.
Not a roll call vote, so you're fine. Any other motions on 44?
Mr. Chair, Daniel S3, I'd like to notify the chair of the intent to offer this as a minority report.
So noted.
Information. Can I request 10-minute break?
Yeah. Or you just want to abstain. Request a 10-minute break. Why? Bathroom? Long day? Break? Yeah. We'll stand at ease. We'll reconvene at 4:35.
Yes. Percent.
Are you finding all this up here at our house? Rachel,
Yes.
And 2 years ago, we made Speaker of the House censurable statewide.
So this one right here?
Yeah.
She sent these to me
Yeah.
too. This is right here.
I'm gonna go off the floor and take a nap.
Okay.
This is this one.
3 days ago.
Oh.
Monday or Tuesday.
Okay.
Simultaneously.
Where I would find it.
Come around here and show me. Come around here, show me what you're talking about.
What I was saying.
Thought I was going crazy.
Yeah. I got you. I got you.
Hopefully I'll be here 2 years and I'll see you.
She sent an email this morning. Nope. I thought it was better.
Yes. Yeah, now an attorney who took out legal language. Imagine that. Yes.
Was this
Which section are you?
so on E, we're using this right here? Just
Here?
if you
Okay.
in parentheses, it doesn't
This
actually
part here?
define it, right?
That's the one that
EG.
they're updating on the
So
screen?
EG, and you got in there,
EG
Speaker
means
of the House.
examples.
Right.
Yeah.
But Speaker of the House isn't
I know.
officially statewide office. So is it somewhere
I know.
else? Hey, Brandon, good to see you.
I understand, but this is just giving them examples.
Sure. Well, I know, but
It says et cetera at the end too.
But Speaker of the House is not a statewide office.
Yeah,
So
but we
unless it's
voted.
defined.
We actually voted 2 years ago that it is.
Okay, so that's in the rules.
That's in the current.
Better
rule.
than I can.
Like here, let me show you. Let me show you what I'm talking about.
When'd you get his? Yeah.
Yeah.
We don't
No,
get to vote on
whoa, chill. I'm asking because
But your representative
I just saw
elected,
it today,
he controls
right now. I
how
had
the
the
house
house
even
I
functions.
understand.
So let
I'm-
me show you what I'm
I
talking
get
about.
what you're saying, but the House
And I can understand.
elects him. He's not a statewide office. I don't
Right.
get to vote for.
I
the
get
Speaker
it.
of the
I get it.
House.
I get what you're saying, but watch. Let me show you what I'm talking about.
I mean, I'm really, I don't have a problem with it. I just want to make sure, since we're trying to simplify.
I-
Oh no. I
don't
get.
know
I get.
what
Oh
it
yeah.
means at
it's-
all.
Yeah. But see
Okay.
here.
So here's
This is the sentence we added. Any county executive committee,
Censored. We were the
Okay.
first
county
one
convention, or
to
senator
censorship
may
for
originate a
state
censure resolution against the Speaker of the House.
Okay.
So we
Really?
basically voted that.
I'm not.
Okay. So,
Yeah,
so
he
is
was
that-
elected in his district, but when he chose
grew
to
up in
run
El
for Speaker of
Paso.
the House, he chose to be a statewide
Okay.
elected official.
So
Basically,
The
is the
original
argument.
verbiage
Then that's
said,
okay.
hey,
So is that
this
in
is what you need.
either yours
Now,
or
it was simple.
the existing?
It's in the
Fill out
existing.
Based
Right.
No,
upon
that stays in the
two
existing.
paragraphs you sent out. You just filled it
I mean,
in.
we start over.
Completely get rid of this and
Go through,
substitute
you
with
wanna look at
mine, and it
official
says the
records,
same
you
in
wanna look
mine.
at timestamps.
Where does it say that?
Now, the
Let me see
Speaker of the
that.
Okay, hold
You're
on.
looking for a voting
Right
record,
here,
voting record.
any county could, just one county
Not
could
all this
sanction the
other
Speaker of the
stuff.
House.
And
But
I
here,
think
hold
you have
on,
a good
I know,
idea.
but hold on,
Yes,
let me
sir.
finish,
Again, I am not disagreeing.
I know, but let me finish, let me finish.
Verify the
So the
stuff.
way it
If
is
you
now,
add all this
it
other
takes
stuff,
one
it's
county
all
to censure the Speaker of the
totally
House.
out of control.
In my version,
RPT
it takes 10 counties to censure the
and
Speaker of
it
the
was
House.
Andy's grade.
Go down. Does
Had
it
to
say at the
verify.
bottom that the Speaker of the House is included?
Unbelievable amount of
It says it right here.
But if you put it in parentheses, that doesn't actually have.
It's the voting record.
The voting record. You need to define who statewide office election is.
Well, this
And
gives
so it
examples.
Well,
says-
he was
I know
stopped
that.
on the stairs somewhere. And
It's not a statewide. If you put it in parentheses, it still doesn't,
But
it doesn't
but
count.
that's not the fact.
You have to.
Verbiage. Where is it
Right?
in
Like,
here?
I mean, as a lawyer,
So,
if you see something in
limited to
parentheses,
journals,
does that
voting
mean
records,
that-
bill numbers,
that
committee,
actual
supplement.
state
Have a committee
definition?
Here's the problem. What goes on in here?
This, yeah,
Well,
that's
I know-
exactly right.
I know
That's
it's
what it
example.
is. It's an example. But
That was
this,
all
when you
it
read
It's
this sentence,
incorrect.
no, when you read this
Official
sentence,
posting.
because the way it is now, it doesn't say he's statewide. It says he may censure of the Speaker of the House. It doesn't say it's there, right there.
If it just says there's a
Okay, no, Facebook will be hacked.
that doesn't actually
by
define
anybody.
it.
You gotta watch that. So,
They say.
Statewide office or Speaker of the House. That
Yes, I like that.
okay, so how do you
This.
verify that? The intent is the true vote. That is record. That's what you need. It's by law. It's how they vote.
Like that.
Here it is.
Yeah, I mean, I'm
That-
not.
What they said later
That's
or
okay.
whatever or what.
I think so.
No, I want to make sure it's. My goal is to make it easy for just anybody who looks at it. So I appreciate your comment. No, I do.
They're just, you see right, turn around.
I'm sorry, I can't.
Penalty one. The SRAC would have 10 plus one. Instead of having for 19. And then actually, if I'm the party rules, I mean, it's all 50. Now I gotta verify all 50. All I need is
After voting to give 5
I didn't
minutes.
get
see a lot more
charged.
the loose for us.
Yeah.
We're gonna censor and get through.
so clear.
The original
For
one's
me,
not clear. The original
live.
The original one is it's like a labyrinth that you have to get through, and then you have to fight the final boss to get to actually get to the
And I, you know, and I understand it, but after as many, people that I talked to, who didn't understand it all, I'm sorry, but
This was a lighter layout. I think you back for the breadcrumb trail and get to the result. This other one, like I say, it's a boss fight. It's a boss fight in a
Take your seats. Bill. Yeah. Justin has one on Rule 44.
I found that.
We did not. Did we? We didn't close. Yeah. No. Secretary have
I didn't make any motion. Huh. Okay, that's rule eight Sierra.
that.
Yeah.
Can the secretary put the language up on the screen? That's huge.
Probably get to eight. That's
We will not see that. Okay. And the screen's not working right now.
Two on the other side. Nope. On? Is it on?
It's on. I see.
Okay. There we go.
Crazy goes.
It's the language in red. Justin.
Mr. Chairman, I'll move for adoption of the language underlined red to the end of Rule 44. Then I'll seek motion.
Is there a second? Second by Dan Pickens. Go ahead and speak to your motion.
Thank you. After consultation with a few members, I'm submitting this because I think some of the frustration has been that grassroots or local organizations are CECs pass resolutions of censure and then it gets up or moves through the process, and at the end they get told tisk tisk because the green card wasn't attached or because the right date wasn't included or on some technicality, the resolution of censure is not fully considered by the SREC. So my suggestion here is to require the SREC to promulgate a form which would include all the relevant information, for example, as a quorum, with principle and the legislative priority do you allege was violated, what date and in what manner, to kind of track Rule 44 to allow and assist people in submitting these in a way that gets them substantively reviewed instead of reviewed on technical grounds. This is not mandatory. It does not create an exclusive form that people must use in order to submit it, but it provides at least some guidance from SREC to receive these types of censures and almost a checklist, perhaps, if you will, so that these can be considered in full substantively and take some of the confusion out of the process. It does not seem like we're going to adopt a complete substitute explaining the process, so at least this puts the onus on the SREC to promulgate a form that somebody, anybody, can go through and get a resolution of censure to the higher levels in an appropriate format.
Craig.
Mr. Chairman, Craig Licardi, SD1. I'm speaking against this amendment for a couple of reasons. Number one, this is a top-down solution instead of a bottom-up solution. And then I'd like to remind the body that numerous times we've tried to create language that gives the origination entities, the executive committees, guidance on how to do the censures properly, with giving them examples of what to include and what documentation needs to be included, and all of those guidelines and all of that assistance we were trying to make to codify the process to make it easier for those who were starting the process. Those have all been voted down. So I don't think that it's I don't think it's wise for the SREC to be promulgating forms to show them what to do. And we've tried to pass that exact thing over and over, and it's failed every time.
Thank you. Anyone else?
Roy, SD8 speaking for the amendment.
Go ahead, Ray.
Yeah, so I don't think it necessarily has to be that the CECs or whoever, they have to use that form and no other form if they provide that they comply with the requirements of the rule. I'll try to be Secretary of State, if you want to file articles of incorporation for this, they provide a form you can use to do that. But other businesses that they can hire an attorney, and then the attorney might have their own format for the articles of incorporation that they use that still comply with all the requirements of the Texas Corporations Code. So I think that this can be helpful to CECs without being a top-down solution necessarily.
Thank you.
Randy Dunning, SD3.
For against.
Speaking against.
Go ahead.
And again, this thing says the SREC shall promulgate forms, kind of forms. See, if you go to the Secretary of State's office to get forms for incorporation, there's actually laws that govern that and that were used to build those forms. This is shall promulgate forms from what? We don't have any guidance in the rule. So there's no guidance in the rule to help the SREC. Now, I can think of where I can find about 3 good points that could probably improve this by making it what the form should contain, because I know where I can find one of those. So, but in its current form, it's not. It's a wash.
Anyone else for or against?
Mr. Chairman, I'll state against. The SREC
Okay.
does.
Do we have any more for that want to speak? Okay, go ahead.
Dr. Morris, 13. The SREC does not want to appear to be leading these species in any way in their ability to censure their representatives. Once they're censured, then that gets passed up to the SREC. But if we're providing the forms for the CEC to fill out, that looks like we're leading the process. So I'm against this amendment.
Thank you. Any more discussion? Seeing none, we'll move to a vote. All in favor of the amendment, please say aye. Aye. All opposed?
No.
The nays have it. The motion fails. Any other on Rule 44? Seeing none, if there's no objection, we will move on to Rule 8. Hearing none, we are now on Rule, oh, I'm sorry, do we have 32 for 8? Yeah, sorry. We have to move on to Rule 32. We are now on Rule 32. Anyone on Rule 32? Seeing none, we will move on to Rule 8.
Mr. Chairman?
Yes.
Mr. Chairman, Robert Gray, SD6. I have a written motion on Rule 8, subsection S, submitted to the Secretary.
How many people have Rule 8 amendments?
Depends what this one.
2, 3, 4, 5. I want to remind everybody, we have a 7 o'clock cutoff. So if the same amendments were passed before and were voted down by anything other than a close vote, or you're not producing something new, please take that into account when you're submitting your amendments so we can get to as many new issues that have come about. It's an amendment to what we passed earlier. I wasn't implying that this was something that we've done before. I'm just noting everybody. Okay, Brendan, do you want to lay out your amendment? Oh, is there a second? The amendment is to amend what the temporary committee had passed regarding felony convictions and eligibility to serve as a county district executive committee member, county chair, SRC member, or state party chair. The temporary committee passed a 20-year time period where a person would be ineligible after a felony conviction. This amendment would reduce the period of time to equal to the amount of time that that person was sentenced for the offense. Who was it? Second by Greg Parker. Do you want to speak to your amendment?
Yes, Mr. Chairman, thank you for laying out the amendment for me. But in addition, Mr. Chairman, so we heard testimony today that that there were delegates that were concerned in terms of the actual time frame. Obviously, one of the things that I brought up during committee was that in the instance of, say, a state jail felony where a person can receive a sentence of no more than 2 years, basically we are penalizing that individual for a state jail felony, for example, with a 20-year penalty, and I think that's really overbroad. And I do raise the concerns that were raised in terms of some more capital offenses or first-degree, second-degree felonies. So I believe this is a reasonable compromise that basically suggests that if you're convicted of, say, a state jail felony, let's say you get if you're sentenced to 2 years, then that period by which you would not be eligible should be equal to that time you were sentenced. So state jail felony, for example, if you're 2 years, it'll be 2 years. For capital felonies of like 25, 50 years or more, obviously 25, 50 years would apply. So I think this is a reasonable compromise to some of the suggestions and testimony that have been made and also to some of the objections I had earlier.
Thank you.
Chairman, David Westbrook, SD19.
David, are you speaking for or against?
I'm against. Oh.
I have an amendment. Friendly one, hopefully.
All right. What takes precedence? Okay, I'm going to call in Justin first.
Okay.
And then David is next. Go ahead.
I'm going to speak against this amendment, and I want to first of all, I want to remind everyone that Texas law does not, it's different. Texas law disqualifies someone from public office forever for the conviction of any felony at all, at all. Your right to vote is restored after you serve your felony sentence, but your ability to hold office is permanently gone. That is what this does, and I want to give you the reason why. We had a person who was convicted 15 years ago of felony injury to a child after they were her husband. There were a 14-year-old and a 14-month-old and 2-year-old covered from head to toe in bites, and then their arms and hands were broken after they wrapped their knuckles on them as a punishment for a 14-month and and a 2-year-old. They were given 5 years in the penitentiary, probated for a period of 5 years, which they had to be revoked. They never did a day in jail, but they were allowed to complete probation, and now we're about to become on our county executive committee. I'm sorry, if that person cannot be eligible to serve as a county clerk, I don't know that we have this big worry that, my gosh, we need to have them on our executive committees. There is still ample opportunities to be involved. You can be a delegate, you can be an alternate, you can be a volunteer, you can do all kinds of things, but holding elected party office, I don't know what our eagerness is. And this would allow the person who was convicted and probated of a felony offense, which lots of places in progressive cities get felonies for violent offenses, to then serve. And I guarantee you it's going to be a headline that the Bexar County Republican Party has a convicted child abuser on our county executive committee. And by God, at least this committee preserved their right to be civically engaged. I do not understand how making this consistent with state law that permanently disqualifies felons, and not even that, it doesn't include drug offenses, it only includes Texas, it doesn't include our president, as was alleged. It includes violations under the Texas Penal Code, which are all crimes involving violence and moral turpitude, such as theft, forgery, and fraud. So I do not know what the eagerness is to make sure that those folks who cannot be our county clerks or constables or justices of the peace can serve on our executive committees, where they have an opportunity, as 44 just allowed them to censure and possibly remove our elected officials off the ballot. I don't know what the eagerness is.
David's next.
Well, I was going to suggest changing sentence to served, but I don't know if I want to do that anymore.
Thank you, David. Anyone else? Hearing none, we'll move to a vote on the amendment. And the amendment is to change the 20 years, strike 20 years, and put a period equal to time sentence for the offense. So a yes vote is for the highlighted language. No vote is for the original language.
Mr. Chairman, point of information, Craig
Yes.
Hardy, SD1. Is this saying that the time served, once the time is served, they're no longer ineligible?
Correct.
Or is it if they got 15 years, it's 15 years additional?
Yeah.
I'm confused over the language.
Mr. Chairman,
Equal to the time sentenced.
Mr. Chairman, my intention, just point of information, my intention was just to ensure, I think to the earlier gentleman's point, that if you were sentenced to 10 years, for instance, then obviously then it should be 10 years before you're able to apply for a position on the Republican Party of Texas.
Mr. Chair, my question is because of the words have elapsed since completion. Is that duplicative?
So you were sure until a period equal to the time sentence.
Like, I could be in favor of saying that someone can't serve while they're in jail or while they're on probation. Once their service is up, then yes.
We're already on a vote. So let's.
Well, it's a point of information because I'm not sure exactly what we're voting on.
You're voting on that language. A period of time, a period equal to time sentenced for the offense, and striking 20 years. All in favor of the motion, please say aye.
Aye.
All opposed?
No.
Nay. The nays have it. The motion fails.
Mr. Chairman, Craig Hardy, SD1, have a motion
Yep.
I'd like to strike section S in its entirety.
Jackson SD 18, second.
Again, we have till 7 o'clock. It's been a motion to strike in a second.
Mr. Chairman, I'll withdraw that.
I
But
think
I'd
we
like to
just
make
pretty
an
much had a
amendment.
test vote on that.
Sir?
No, I'm just saying, I think we pretty much had a test vote on that.
Yes. So the existing language is back to the 20 years.
Yes.
Okay, I'd like to make a motion to modify 20 years in the two instances where it has the 20 years, I think, to make that 3 years.
It's been a motion to modify 20 years to 3 years. Is there a second? Hearing none, the motion fails. Any other motions on Rule 8? Seeing none, if there's no,
Mr. Chairman, I sent one to Rachel.
okay.
It was amendment for Rule 8S, but actually it would be a new category, so it'd be Rule 8T.
Yeah.
It's just S is the last one. I happened to stumble. That's what I thought. Nothing that's like did not put nothing. Here's the end right here.
It's been a motion to introduce a highlighted language
That's mine.
as Rule 8T. Is there a second?
Second.
Second by Craig LaCordy. Do you want to present your motion?
Well, this is just a restriction of employment for people serving as on county executive committees to avoid conflict of interest.
Anyone else? Yes, go ahead.
Is this already addressed in Rule 42, employment with the RPT or contracted services? No, I mean,
Hold on, I'll get you an answer in 2 seconds. SREC members. So what's
only SREC?
Yeah, I think 42 refers specifically to SREC, and this is for county executive committee members.
that isn't an SREC. That's 42 is SREC.
Not the county.
Yeah, this amendment's not germane to Rule 8. It's ruled out of order. Anyone else on Rule 8?
Mr. Chairman, Craig McCarty, SD1. At the risk of sounding dilatory, I do have some new language to replace 8S. That should be in the secretary's inbox.
Gary. Is there a felon for that? Just
Maybe people need to talk to Daniel. He's a criminal.
Just go. Yes. Language.
Chairman, is out of order.
No,
second
the
one,
original
the
amendment
long-
was he's going back to 8S.
It does the whole thing.
That was the felon
2 emails from you.
section.
Not the first one.
So a total replacement of 8S?
The one I sent like 2 minutes ago.
Okay.
Oh, did they withdraw T?
It's a strike and replace. What is striking? You have struck. You put a strike through on it so we can visualize it. Wait, what? Okay. No, I meant.
Sorry.
What'd you do? You have to do.
I can strike it.
No, it's right up there. Why are they doing this? The AB. That's how you strike through it. But you know that's an easy strike through. Right? Right there. See?
Never do it though.
I'll be giving word tutorials after the meetings adjourn. Oh my gosh. Okay. So it would be striking striking 8S, which is the language we were just viewing regarding felony convictions, and substituting it with the language below. And is this correct?
Is this a lifetime ban?
Shall be restored upon successful all terms
Is that correct, Craig?
Yes, Mr. Chairman.
Okay. And there was a second by.
This is point of order.
Who was that?
Point of order. I
Justin.
think this is substantially similar to the exact amendment that was just voted on, and so it's out of order. It's not substantially different.
I was going to say, yeah.
Oh, sorry. Whatever, that's his.
We don't have a second yet. Second by Robert Gray.
Make your point of order. Oh. Point of order.
Yeah. Go ahead and speak to it. Overrule. You going to speak to it?
Yes, sorry. I didn't hear the second.
There was one. Robert.
Thank you. Mr. Chairman, a bunch of this language is identical. Rather than try to piecemeal a few things, well, there's one substantive change, and I believe it accomplishes what was done prior to what we tried to do earlier. Instead of 20 years, it accomplishes the time served. So if someone's been if someone served time in jail for 10 years for whatever, making their sentence, we're imposing a 30-year sentence on them before they can participate. The 10 years that they serve is they've served their debt to society, and it would be up to at that point they've served their debt to society, and so rather than us adding on an additional 20 years of punishment to their sentence that's already been completed, it would allow them to serve.
Point of order.
Please state your point of order.
This seems dilatory. It's the exact same thing what we've been talking about.
Point of order is sustained. Anything else on Rule 8? Seeing none, we'll move on from Rule 8 to the general rules in reverse order. So that would be starting with 45, 44, 43. Starting Rule 43. Does anyone have anything on Rule? I'm going to go auctioneer a little bit now because we're running out of time. So be sure you go quickly. Have you been
Mr. Chair,
submitted? Yes, Chris.
Chris Bird, ST 25. Just letting you know in advance, I do have something on Rule 41 and Rule 20.
Okay, I'm just going to go through it. Okay.
Sure, where he's going to start.
So we got Rule 43. Any on Rule 43? Seeing none, we are 43 is closed. We're moving on to Rule 42. Any on Rule 42? Seeing, yep, go ahead.
Rohit Joy, SD8. I just believe that there's a conflict between a couple of the things we've added. I talked to the secretary about this. So where it says members may not, or SRAC members may not manage non-Republican candidates seeking office in a partisan election, further down, you say it can't be receive compensation for political campaign at all. So my recommendation would be to just delete that sentence because there's a more restrictive provision farther down. And then I would also suggest just moving that the SRAC shall be authorized to approve the minutes of the state convention. That should just go to the bottom because that's a separate topic. It shouldn't be in the middle of language on.
You're moving to strike that sentence.
Yes, and to move the SRAC shall be authorized to approve the minutes. Just move that to the end of the whole paragraph because it's right now it's kind of in a strange place.
He just wants to move it because
Mr. Chairman, point of information, Andy Eller, SD24.
Please state your point of information.
I'm trying to understand what's being stricken. It's the sentence.
SREC members may not manage non-Republican candidates seeking office in a partisan election.
Okay, I'm sorry. I was looking at the sentence before that.
That following sentence is being moved to the end of the paragraph.
Okay, thank you. I was just looking at the wrong sentence.
Okay, is there a second? Hearing no second, the motion fails.
She seconded it. She seconded it.
Oh,
Super SD12, I second.
all right. Second by Amy Super. Would you like to speak to your motion?
Yeah. So again, the sentence, any individual who is a compensated employee of the Republican Party of Texas or its partners, affiliates, etc., may not serve as an SRAC committee man or committee woman. No person shall be eligible to serve as a member of the SRAC while employed by, contracted with, or receive compensation for any political campaign public office. So, I mean, that language covers, Republican, partisan, nonpartisan. It just says if you're being paid to do on a political campaign, you can't serve on the SRAC. So there's no need for that that earlier sentence, which is less restrictive.
Josh Flynn, SC15. I think this covers people that are volunteers. Not just the compensated ones, but the ones that go volunteer for a Democrat party or Democrat.
Oh, well, I mean, if that's the case, then instead of saying manage, it should be they can't be involved in supporting Democrats at all. I mean, when we say manage, I mean that's more of a professional capacity.
Yeah.
It seems like that would be a little bit more evidence-based, but it still allows it to be not. I mean, I've done a lot of work for Republicans that I don't get paid for, basically managing smaller campaigns and things like that, but it wasn't ever compensated for.
Anyone else in favor or against?
I'm going to speak against.
Go ahead.
One, the top one, what we're striking there on the members may not manage non-Republican candidates in partisan office. I would say the vast majority of campaigns have a volunteer campaign manager. And when you're talking about small ballot, that included them earlier. So I think that was better. Second part is, and this will be, I guess, me as a paid campaign guy, I think I have value. I think I bring a lot of volunteer time. I'm definitely not compensated to sit here and do this. And I think I have a lot of experience I can bring to the table. And I think there are several people who do take pay. We're talking about people also who sit there and compensated could also include gas money on that we've given to volunteers. Like that language is compensation per the and it's going to be on a TEC report as money given to that individual. So I will oppose this amendment.
Point of information.
Please state your point of information.
Randy Dunning, SD2. When it says not managing non-Republican candidates, when I ran for city council, I was a nonpartisan candidate because there was no party declaration in city council races in many cities in the state. Would that be covered in this?
No, it's seeking office in a nonpartisan election.
Okay.
Mr. Chairman,
Other than candidates seeking office in a nonpartisan election.
if I could ask a question, Mr. H, that'd be acceptable, just to understand your concern.
Yeah, do it during argument, and I'll go to Chris Sation next.
Okay, so just to be clear, that the current language right before my amendment says that you can't, if you're paid, right, as part of a campaign, you can't serve any of those roles. So, I mean, would it be better then, for your purposes, to just delete that part and keep the part that I was proposing to delete? Because I'm just trying to resolve an apparent conflict mainly.
Yeah, give me 1 second to read that.
Okay.
I'm not necessarily opposed to that.
Chris, do you want to speak?
1 moment, just trying to absorb what he's asking.
Mr. Chairman, point of information.
Yes, please state your point of information.
Craig Licardi, SD1. So when we're striking the language says SRC members may not manage non-Republican, that's stating that making it so that they can manage non-Republican candidates. So we could have Republican SREC members helping Democrats get elected if we strike this language.
As long as they are not paid.
Wow.
Point of information, we had an SREC member managing a campaign of a Green Party candidate that was SREC. So if you're a representative of the Republican Party, should you be involved in campaigns of other party candidates? No.
We'll put that.
Sometimes we have to state
Stephen
the
again.
obvious.
David? Good. Anyone else? Move to a vote.
Well, Mr. Chairman, did Mr. Sesha answer?
Yes. Go ahead.
My answer is that would be better by Bill, and in the interest of time, like, I don't think this gives us that much. If we go back later and add something on lobbyist specific, sure. But against.
Point of information.
You state your point of information.
Dan Biggins, SE 28. Due to my raging migraine, can you exactly tell us what we're voting on specifically?
You are voting on striking the phrase. Okay, let me, any other discussion? Hearing none, discussion's closed. You will now be voting on the amendment, which is striking the phrase SREC members may not manage non-Republican candidates seeking office in a partisan election, and moving the phrase, the SREC shall be authorized to approve the minutes of the state convention to the last line. All in favor of the amendment, please say aye. All opposed? Division? Kidding. We're moving on. The motion fails. 21. Sorry, it's getting late.
Mr. Chairman, Brandon Moore, SD21.
Go ahead.
And maybe I just missed this during the temporary, but that same rule that we were just discussing, Rule 42, to make a motion.
We're on Rule 8. Oh, wait. We're on Rule 42. Yeah, that's right. I'm sorry. Go ahead.
Right now, I believe on the document, it's at the top of page 45, where it says no person shall be eligible to serve as a member of the SREC while employed by, contracted with, or receiving compensation from any political campaign for public office. And then nor may any member of the SREC serve as an employed lobbyist. I would move to strike after the word SREC in that first line, strike while employed by, contracted with, or receiving compensation for any political campaign for public office, nor may any member of the SREC. strike that. And if I get a second, I would like to speak to it briefly.
Okay. Go ahead.
Okay.
It's your mic.
My reason for this is we have SREC members. It's a volunteer position. We have candidates on the ballot, Republican candidates that go on the ballot, and nominees that go on the ballot against Democrats. Why should we say the SREC can't receive compensation for helping our nominees beat Democrats? That's really the only thing. I mean, yeah, maybe we want to say it they can't do it in a primary. I don't know, but definitely they should be able to receive compensation if it's agreeable for helping beat Democrats.
Yeah. Anyone else?
Mr. Chairman, Mr.
Yes.
Chairman, point of information, was there a second?
I'll second.
So, I'm sorry. Rohit second.
So I'll second it and I'll speak if that's.
You're going to second and speak against?
Or no, no. I will make a friendly amendment. Sorry. Okay, yeah. So friendly amendment.
You're speaking for or against?
Well, I'm for it, but I want to make a friendly amendment before I.
Okay. Go ahead.
So. So right now it reads, no person shall be eligible to serve as a member of the SREC or serve as an employed lobbyist. I think what you're intending to say is no person shall be eligible to serve as a member of the SREC who is employed as a lobbyist. Because, yeah.
Okay, so what is the proposal?
So my proposal is to strike or serve as an employed lobbyist with who is employed as a lobbyist.
That's not really germane to this.
No, it is because it says, "Oh, no person shall be eligible to serve as a." Okay, okay. Well, then figure.
This is specifically regarding campaign personnel.
I understand that, but it makes the sentence not make sense. So if there's a better way to correct it, then fine.
What is it? Yeah, what is it? I'm trying to. Is it grammatical? Okay. Go.
Yeah, that's what I'm trying to fix.
So specify what it is. It's the word, yeah. No person shall be eligible to serve as a member of the SREC. Oh yeah, that doesn't make any sense with the or. Nobody's eligible to serve as a member of the SREC. That's the rule.
I moved to call the question.
Good catch, Rohit. He just averted disaster. No member shall be eligible to serve as a member of the SREC while employed. While serving as. Yeah. While employed as. So you don't have to strike as much. And then you put no while employed. Yeah, then you strike serve. No, so no person shall be eligible to serve as a member of the SREC while employed, while an employed lobbyist. Or... No. Unstrike that. It's just you're talking about the connector. Yeah, no person should be eligible to serve as a member of the SREC while an employed lobbyist.
I mean, if you want to make that, you can and explain it. You know.
While employed as a lobbyist. That would be probably grammatically better.
Against the amendment.
Employed as a. No. While employed as a. Yeah. Okay.
Mr. Chairman,
Hold up. What is it?
I'd like to offer a friendly amendment.
Oh boy. Hold on, we got to finish this one.
Sure. I'm in the queue.
Go ahead, Brendan. Does that accurately state?
Yeah, but Susan, for that you have to do a separate amendment because it's not germane to.
Employed as a, no person shall be eligible to serve as a member of the SREC while employed as a lobbyist. Instead of the passive while serving as an employed lobbyist. Okay. Friendly amendments accepted. David.
Mr. Chairman, I'd like to insert the word registered as right before lobbyist. I think the registration makes, excuse me.
This is dealing. Okay. So other than a grammatical fix, which was the first was a grammatical fix. This is substantively different, not germane to the original amendment, which was dealing specifically with campaign workers. So we would have to wait until this is done and then deal with that after.
So
Hold on.
being
Point of information.
this particular
Move the mic down.
s-
Point of
so
information, are you?
no, I'm saying so
Are
you're
you
saying
speaking
we
for
have
or
to make
against?
I want to speak against this amendment.
Okay, hold on 1 second. And I got you as against. Hold on. Okay, we're all set. This is the amendment on the floor. Susan, go ahead.
Yes, Susan Lucas, SC5. This amendment needs to not be this needs to not be changed. It needs to be left as it is. We have people on the SRC who are working in uh, political elected political offices, and they are being influenced by what they are having to do and get the advice they're giving to their employer, and then coming to the SREC and not looking at the issues with uh, a clear and uh, unbiased perspective. They are spending more time trying to protect their employer.
For or against? Okay. Anyone else for or?
Mr. Chairman, Brandon Moore, SD 21. Can I respond to?
Yeah.
Okay.
And then Craig.
I get what she's saying, and I would agree with that. But the language that was there said, while employed by, contracted with, or receiving compensation from any political campaign for public office, not not not. It doesn't cover those that are being paid by the public office itself, only the campaign.
They deleted that line. No, it was there. It was there and was deleted. It was
Oh, it's all new language.
when the rule was first evaluated.
Okay. Hold on. We're going to speak for or against.
Against.
Who's correct? Go ahead.
Gargakari SD1. Definitely speaking against this. It needs to be like it was prior to, just like my colleague down here said. It necessarily engenders a conflict of interest when you have someone who is paid by an entity and it compromises the independence of the SREC member when their income and their livelihood is being funded by something that might be at odds with what the SREC is going to have to take up. It's an absolute conflict of interest, and we need to vote this down. Thank you.
Anyone else? Yes, go ahead. You're against or for?
Yes. Mr. Chairman, I'd like to read. Mr. Chairman, I'd like to read from the SREC bylaws, Rule 41, about, well, no, excuse me, but bylaws about the Candidate Resource Committee Code of Ethics that have been in place probably over 20 years. It says, any person who holds an elected office or is a candidate for elected office has filed for appointment of campaign treasurer. Well, that's the wrong one. I'm sorry. Any person who is employed for compensation, either full-time, part-time, or as a political consultant or as a staff of an elected official or candidate. And this is in the prohibition of being members of of the SREC's Candidate Resource Committee. And the other one is any person who is a spouse of an elected official, candidate, political consultant. The in about the 16 years I've been involved with the Candidate Resource Committee, we've never had a violation of those code of ethics. And I think that's we should be considered that kind of threshold for the entire SREC, including at a debate between Dorinda and Abraham at the Tarrant County Republican Assembly, both agreed to these kind of standards for the SREC.
Thank you, Chris.
I'm speaking in favor of the amendment. Quite simply, I do agree with you that the Candidate Resource Committee, which is having the SREC give money to candidates, should not have people on there who are going to be trying to pull for their individuals. But also, we have several great volunteers in this party who get hired on a small time basis by Governor Abbott's campaign and others to serve as volunteer coordinators because of their volunteer activity. I don't have names in front of me right now, but we have multiple people that were big grassroots folks who have taken on paid positions to help lift campaigns. We keep on kind of yo-yoing back on this, but also at the end of the day, young people who have time for politics are people who work in politics. The rest of us, they have to go work. So it can sit there and it can be focused on people who have been blessed with more incomes or people who have their window, but at the end of the day, like we are just chopping people off who don't really have that much influence over how that goes, especially when you say any campaign, a guy could go work and help a local city council guy get a $2,000 helping fee, block walking, whatever, and now he's not work on the SRED. That seems unnecessary. I'm in favor.
Thank you. Else? Seeing none, we'll move to a vote. All in favor of the amendment, please say aye.
Aye.
All opposed?
No.
The nays have it, the motion fails. Anything else on Rule 42? Seeing none, we'll move on to Rule 41. And being on Rule 41, we will also take a 10-minute break because it's been an hour. Be back here at 5:40. And everyone's starting to stand up because they're tired. So we'll stand at ease until 5:40. That's it?
All I have.
41. Do you have anything else besides the one?
Only this and 20 and most of 20.
Everything against 20.
That's the one.
Oh, come on, dude. It's literally Austin.
What were we on? We're on Rule 41.
What rule is it on? Hold on, what rule is it on? Mr. Chair, I move that we accept the report as amended and allow the secretary to do any grammatical cleanup.
I second. Okay. A motion and a second. Any?
You ready to go, huh?
Been a motion to call the question. All I want to call the question on the motion that's on the floor, please say aye.
Aye.
All opposed? The ayes have it. We're now voting on the motion, which is the motion to
Accept the report as amended and allow the secretary to do any grammatical cleanup.
motion to accept the report as amended and allow the secretary to do any grammatical cleanup. All in favor, please say aye. All opposed? The ayes have it. Can I get a motion to adjourn? Motion by Josh, seconded by everybody. We'll say Matt.
Okay.
All in favor, please say aye.
We're adjourned.
Opposed? The ayes have it. Thank you, everybody on the committee, and thank you, everybody who's testified. I appreciate all of the long hours this week. It's been a pleasure and an honor.
Removing.
30 minutes.